welcome to all of you. Thank you very much for joining this panel. So this session is a session, as you can read on the slide, it's a session about the relationships between data protection and AI. Of course, these relationships between AI and data protections are delicate. Why? For a very simple reason. AI needs to be fed by data, and of course, data protection restricts the use of data and the collection of data. So the interplay between the regulations, both in data protection on the one end and AI at the other, create uncertainties that need to be discussed and examined carefully. And therefore, we have four interesting speakers here that have a common point. They are all authors in a book published by Nomos and Art, which is called, it's an article-by-article commentary on the GDPR. So the first speaker is Sophie Stala-Bourdillon, who is professor in IT law at VUB and the Privacy Hub and principal legal engineer at Immuta Research. She's also visiting professor at the University of Southampton Law School of Law, where she held the chair in IT law and data governance since until 2022. She is editor-in-chief also of the Computer and Security Review, which is a leading international journal of technology law. Our second speaker is not Giuliano Marano, as indicated behind, but is Marco Almada. Marco Almada is a researcher at the European University Institute in Florence, Italy, and is working on AI regulation. Before joining the European University Institute, Marco obtained degrees in law and computer science in Brazil and worked as a data scientist and as a policy researcher. Afterwards, we'll give the floor to Vagelis Papakonstantinou. Vagelis, as you might know, is a professor of law at the VUB, but is also an attorney in Athens and at MP Legal law firm. In Athens, other than consulting SMEs on IT law, he is the DPO of a large political party in Greece and the Athens Chamber of Commerce. Before that, he has served in the board of directors in the Greek DPA and the Greek Intellectual Property Organization. And finally, last but not least, Professor Indra Speaker, which is a professor in public law, law of digitalization and legal theory, University of Cologne. Previously, she was a professor at the University of Frankfurt as a successor of Spiros Simitis. She wrote multiple advisory opinions for courts, NGOs, companies on data protection, IT security, and regulation of digitalization. So, I'll say it again, all these speakers were authors in a book that was co-edited by Paul de Hert, Indra Speaker, and Vagelis, as well as Professor Gerrit Ornung, which is article-by-article commentary on the GDPR. I'll give the floor now directly to Sophie, that will explain us some issues and some uncertainties in the interplay between AI regulation and data protection regulation.
Okay, thank you very much. Would it be possible to show something on the screen? Okay. I have a bit of animation just to warm you up. My role is to set the scene. I mean, it's a difficult topic. I'm not going to lie. So what I thought I would do is to unpack a little bit legal uncertainty, to try to see what it is not, to try to better identify the roots of some of our problems. With rulemaking comes legal uncertainty. Rulemaking, though, does not necessarily lead to innovation chilling. That being said, rulemaking often leads to legal uncertainty. And therefore, the question that we've got is, what do we actually mean by legal uncertainty? And I would like to distinguish legal uncertainty from four different concepts to help us identify, as I said, where the problems are. So my first distinction, the distinction I would like to draw, is between legal uncertainty and legal inconsistency. If I look at the AI Act and if I look at GDPR, what I can say is that there is clearly an intention to come up with a complementary approach. If you look at some of the articles, and in particular 2, 10, 15, 85, and 86, there is an intention to broaden the range of remedies, the range of obligations imposed on some of the actors, starting with the providers. Therefore, there is very much an intention to broaden the framework, even if for the AI Act, obviously, the distinction between personal data and non-personal data is not relevant. That being said, and I would argue, GDPR remains very much the foundational layer for two reasons. The first one, because lots of personal data is being actually ingested and used into training data sets to build the models. And the second reason is that the AI Act is actually focusing on high-risk AI systems. And so the rest is largely regulated by GDPR. And as I said, they are complementary, and that's done, at least at a high level, relatively well, in the sense that GDPR is principle-based, is horizontal, and I would argue it's use case tolerant. And in particular, if you look at Article 5, you will see that these principles are actually goals that generate trade-off, and therefore not every use case will lead to the same results. Not everyone agree with this. Some would want to have seen some sector-specific regulations. Now, if you look at what's happening in the US, they've got sector-specific regulation. I'm not entirely sure they've got the right solution. So we've got a principle-based approach, plus some red flagging that is coming from the AI Act, and in that sense, I would argue this is complementary. The second distinction I want to draw is between legal uncertainty and then technological uncertainty. And I think the second one is actually quite problematic, and I would argue even more problematic than the first one. Just take one article of GDPR, Article 30, which has branches with the AI Act, and in particular Article 10 and 15. And what do you see in practice? Where we can't get, I mean, it's very hard to get a full breakdown of the elements that your tech stack is actually processing. Is this related to a legal uncertainty problem? Not. I would argue it's related to the technology itself that is not making things easy for the compliance team. And I'm just taking one example. I'm not trying to do any marketing here, but this is a tool that's being used by lots of RevOps teams, and in particular marketing teams as well. It's very hard to get the full range of their elements there if you want to do the record of processing activities properly. The third distinction I want to draw is between legal uncertainty and human denial. And that's the problem that I see often in practice. I hear that very often, actually. It's all very nice, they'll tell me, but I don't have lots of personal identifying information. So the GDPR framework actually does not apply. It's not actually true, or actually it's not the right way of setting the problem. Why? Because we're interested in personal data, not in PII. That makes a difference. And there are two very important criteria that you need to bear in mind when it comes to personal data. Singling out. If you know what singling out, you're on the right track. And then if you know what the processing purpose is or could be, then you're on a very good track. And if you look at the mainstream analytics use cases, which consume lots of tabular data, then you are going to be able to say, okay, this table relates to individuals. It's too loud, is that right?
No.
No?
You can't hear well in the back.
I
think it's fine.
Yeah, I'm not sure what I can say, because I'm very close to the mic, so more than that, yeah. So if you, as I was trying to speak about the tabular data that you get ingested in all the big data ecosystems in order to do the analytics and the modeling, it's not that complicated to make an argument that lots of things is actually personal data. And even if, in the first place, the data does not relate directly to an individual, but to, like, say, a vehicle, if there is an intention to use this to learn things about individuals, then there is a good claim that this is also personal data. So I would argue there is some denial happening that is making things more complicated than it should be. The last distinction that I want to draw is between legal uncertainty and human hubris, and I think that's part of the problem. Even ChatGPT knows what human hubris is. Human hubris can be defined as the excessive pride or self-confidence in humanity's abilities and knowledge or accomplishments, often leading to a disregard for limitations, potential consequences, and the broader impacts of actions. And this could lead to significant, sometimes catastrophic outcomes. And I think if I had to pick a movie to reflect where we are at today, that's the movie that is the most appealing to me, the Sister Brothers. They're all looking for gold or AI, and they are not really interested in the consequences of their actions. This is where we are at today. And if that's the case, then we need some breaks. Now, I agree. Not every breaks are equal. Some are more sophisticated than others. But we need some. So if you look at GDPR and the AI Act, what you see then is an attempt to create some breaks. Now, I'm not going to argue that they are all very well functioning. And in particular, Article 5 of the AI Act, I have some doubts about it. But there is clearly an attempt to do that, and in particular with the list of high-risk activities. Now, obviously, legal complexity nurture legal uncertainty. And I would say the AI Act has probably won the lottery ticket here. Has made lots of people dizzy, and it's probably the best description of the act is a gruyere. There are many holes in there. That being said, I have a but, and I should maybe make it bigger. Time is accelerating. And if you look at adoption of generative AI in particular, you will see that the time that they took to reach 100 million users has shortened in comparison to previous applications. So we need to react and react fast. Gartner even says that more than 80% of enterprises will have used generative AI APIs or deployed generative AI-enabled applications by 2026. And they say this even if they have a very fancy hype cycle. We are at the peak of inflated expectations today, so we are going to go down. Lots of people are going to be have disillusions. So, but anyway, this is going to be used, and this will happen. They say the plateau of productivity will be reached in 2 to 5 years. So some time will pass if we just wait and see. Some damages will be caused. So we need an airbag. That's where I almost reached my conclusion. I just want also to flag that there is obviously an elephant in the room, which is big AI. GDPR and the AI Act are not really built to tackle that particular issue. We will need more to do that. But I leave it there. And with this, I conclude. I have 2 quotes for you. Just pick the one that you like the most. The first one is from D'Amato. If we could educate the public or the lawyers that fairness, practical reason, and justice considerations have considerable weight in determining the actual content of the law, then legal certainty could be increased. That's the first one. And the second one, maturity is the capacity to endure uncertainty. Pick the one that you like the best, but this is where we are at. Thank you.
Thank you very much, Sophie, for setting the floor. I'll now give the floor directly to Marco.
Thank you. I will start by it's a pleasure to be here, and I'll start by following up on Sophie's second wrapping up quote on maturity and the way to deal with maturity as a way of dealing with uncertainty. And this connects directly with the contribution that Juliano Maranhão, who was the original speaker here, and Giovanni Sartor made to the edited volume that Frank mentioned earlier on the commentary of the GDPR, in which we tackle Article 25 of the GDPR, which deals with data protection by design and by default. In short, and the provisions of Article 25 establish that data controllers, whenever they are happening processing, they must take technical and organizational measures to ensure that whatever processing they're doing observes data protection principles. And at our commentary, we highlight a few points that are critical for understanding this navigation of those various kinds of uncertainties, legal and whatnot. And one of them is that given the way those data protection principles are construed in the GDPR, it's not simply a matter of following principles of Article 5, but you have a broader construction that includes also, that establishes that the controllers have an obligation when choosing the means for processing to look at the impact of those means for processing at a broader range of fundamental rights, given the need to observe the protection given in the Charter. And this is not really a side gig for the AI. It's not simply another means of protection, but rather, given all the technical uncertainties, which should not be confused with the legal uncertainties, as Sophie pointed out earlier, it becomes a situation where the adoption of technical and organizational measures becomes fundamental, not just to avoid problems from the side of the controller, but also to allow the data subjects to exercise their rights, because they need channels that allow them to engage and exercise the multiple rights, and also for authorities to be able to properly supervise what's going on in the system. So, as several scholars have pointed out already, the Article 25 becomes a central element on the enforcement system. This is something that we highlighted in our commentary and has been borne out in practice, as lots of data protection authorities and judicial decisions on data protection have been invoking Article 25. So it is a quite crucial provision if we are going to understand the data protection system, and it becomes particularly relevant in the context of AI, because when we are talking about the technologies we have seen those days, we're dealing with systems that use large amounts of data, and much of it ends up being personal data, given the difference between personal data and personal and PPI. So you have not only these massive uses of data, but that is used to create algorithms that are often opaque, in the sense that people can't understand what's going on, not just untrained, not just the external observers, but even technical experts may struggle to make sense. So you have a sense where the technical uncertainty that we have here regarding how those systems work, what kinds of outputs they can produce, what processes they follow to that, becomes closely related to legal uncertainty, because when you have an obligation that's created by data protection by design, where providers are expected to take legal requirements and translate them into technical requirements to adopt technical measures and requirements that shape organizational measures that you adopt in a particular context, then that gives you a certain where if you don't understand what's going on the technical side of things, when you translate technical requirements into the law, that might lead to different interpretations, or might lead to a situation where it's not really adequate representation, or you might end up embedding into a computer system requirements that reflect a reasonable interpretation of what the law requires under today's technologies, but as technology evolves, they might not be reasonable anymore of that. And what changes when it comes to that with the AI Act? Because, in a sense, the AI Act gives you more certainty regarding the obligations surrounding AI systems, because if you go to the requirements that apply to high-risk AI systems, all of them entail some sorts of technical measures. You have requirements regarding the data that is used to train and validate and test AI systems. You have requirements regarding the human oversight, requirements regarding the accuracy, among many others. And those come to what is actually a broad text in the GDPR, because Article 25.1 says technical and organizational measures without entering much into detail into what goes on. And then the AI Act comes and says, when you're dealing with a high-risk AI system, you have to adopt these and these measures that will address the risks that AI systems of high risk may cause. However, this does not mean that the AI Act manages to successfully eliminate any uncertainties regarding the contents of the law when it comes to regulation by design. First, because the AI Act broadens the interest, because as I mentioned, while the GDPR Article 25 requires attention to the fundamental rights, which is also present in the AI Act. The AI Act has this broader ambition of protecting fundamental rights, democracy, the rule of law, and environmental factors, which expand the set of legal factors that data controllers must consider when they're designing the AI systems. And at the same time, the AI Act narrows its scope, because when it establishes the measures that must be adopted, it obliges the providers to adopt technical measures, that is, changes to the computer system itself, whereas the GDPR allows for technical measures, changes to the system, and organizational measures that regard the context in which those systems are deployed. And while the AI Act does include in its approved version obligations to the deployers of AI systems, those are much less extensive than the ones provided in the GDPR. And so we have here another way in which the AI Act does not fully reduce the uncertainty regarding the content of the obligation of regulation by design. And another factor that comes into play here is that the AI Act, the bulk of the applications you see in the AI Act, all those extensive requirements for technical design, the procedures for control, they're focused on a handful of systems. You have obligations for high-risk AI systems, which the European Commission estimate are going to be from 5 to 15% of all AI systems in the EU, so most of the systems are not covered by that kind of obligation, and some obligations for general purpose AI models with systemic risk, which is a category constructed to be narrow. So we have a context where, okay, the AI Act provides us with some guidance regarding the content of design, but you still have a big uncertainty regarding, okay, what does the law actually require in particular contexts, and which the GDPR acts, as Sophie was mentioned earlier on, as a baseline here that offers, because even though if you're dealing with a system that's not high risk, you don't have particular guidance regarding its risks, you still are obliged under the GDPR to adopt technical organizational measures to protect rights and address that. And while interpreting this content, the measures provided in the AI Act, and of course the forthcoming materials that will support the implementation of the AI Act by the AI Office and other sources, can offer a potentially effective guide for understanding what this regulation by design actually entails in the context. But just to wrap up, I want to say that even though the AI Act is a step forward, in the sense it does not really banish the uncertainties that come from the GDPR, and so it's important to understand those measures that are required in terms of the systemic view of, okay, what does the data protection require overall, rather than stopping at this particular horizontal instrument. Thank you.
Thank you very much, Marco, for this presentation. I'll give the floor now to Vagalis Papakonstantinou.
Okay, thanks. Thank you, Frank. Thank you, everybody. I admit that today I plan to take advantage of you and launch a thought that I have. I'll put it on a blog post in a few days, but I wanted to use this opportunity as good as any to launch this, my biggest complaint with the AI Act, and then I'll make the connection to the GDPR a bit later. So I'll use my 5 minutes only for that. So my biggest complaint with the AI Act is that it does not introduce a right to AI individualization. For me, to individualize, for me as a user, so for people, for humans, to individualize their AI. It adopts an organizational, horizontal, technical nature, and is not addressed to individuals. It does not allow us as persons to do anything. And what we could do, actually, is we could individualize, personalize our own AI. So that's the basic idea. So in practice, how does that make itself visible? So in practice, I do not actually want to talk to Siri, and Siri transmitting all my information and questions and wishes and ideas and life to Apple to process, and then get me the results, of course, personal, but still processable by others to help other users. But still, it's not my Siri, it is everybody's Siri. All of humanity is talking to Siri, Alexa, Cortana, etc. We're not talking to our own AI, personal agents. We are talking to the cloud, to a single entity, actually. And the same is the approach, actually. So I'll get to that, but it's a trick that we have been led to through by the industry and scientists, actually, to speed things up. And the same is approach with ChatGPT. We are all entering our questions in a single machine. So the single machine gives us replies. At the same time, it uses our feedback, our questions, our wishes, our thoughts to improve itself, right? But it does not get personal. It is not mine to improve. It stays an entity common to everybody, improved by everybody's knowledge, aimed at processing everybody's data and all of the data out there, but it is not becoming personal, individual, and separate only for the user, for me. Same with Amazon's recommendation algorithm. You get the users who bought this book also bought these books. But at the end of the day, it gets a bit personal, but it's not mine. If it lived with me and it was feeding through my data, and it was mine, I could individualize the machine in a way, then I would get more meaningful results. Or with Spotify, my lists. You always get other users who listen to your music also listen to this. Other users who read your books also read this. But where is my own AI that knows exactly what I'm, and it's rarely, functional. Sometimes it is, most of the times it isn't. But where is my AI that I can train over the years? Where is my series? So it's called, I don't know, Maria or Tom or whatever. But I can get it personal, it can grow with me, and then it can be really individual. And plus, it does not contribute to the common hive, to the common AI entity that is placed by definition across all of humanity. Each one of us individual, but a single entity to the other side of the table. Now, of course, I am not being selfish in this case, and I want humanity to improve, and the AI to improve, and the algorithm to improve through learning of my usage and my processing. And this is where the GDPR comes in. But I want to have complete control on what I'm transmitting and what I get in return, and who the data goes to. Because for the moment, you get some personalization, some cookies, but the approach is, again, that you are talking to Siri, so you can somehow personalize, but Siri transmits the data to the central hive. I can sometimes limit, but do not have my own AI agent growing with me, not transmitting the data further by definition. And of course, if I allow it to, through data altruism, data management, EU data strategies, etc., then it's fine. This is not the approach. The approach is exactly the opposite. Data are transmitted to improve the machine across us, unless I tell it not to. So the approach to me is a bit twisted. So in fact, and I'm finishing with this thought, actually I think that the industry and scientists have tricked us for the moment because they want to make quick progress, because they want to improve AI as quickly as possible, and because they want to make a quick profit. Of course, they are collecting our data, harnessing our data, using it to improve the machine, but not giving us the opportunity to individually grow with individualized versions of the machine. And to even better visualize this, I think that what we are actually doing for the moment is we are building Skynet. So for those of you who are familiar with the Terminator movies, we are building a collective mind that knows everything, but is a single entity, poised to discuss with all of us. So Siri is a single entity discussing with 5 billion people on the planet. It is wrong. Each one of us have the right to create our own AI agent, be it entity, be it, to grow with us individually, not collectively, so the viewpoint changes, and thus improve with us, and through control of us, of the flow of information. So this is the idea. I'll put it, on some more detail on paper, I promise, but I wanted to launch with you and see how you feel about it. So thank you.
Thank you very much for your insights. I get it. I'll now give the floor to Indra.
I'll be a bit more down to earth, which is part of my job, because Vagelis and I co-authored, together with a number of other people, a commentary on the GDPR, which basically meant that we were going with our authors sentence by sentence, paragraph by paragraph, through the individual provisions. And so this is sort of an extension of the Kuna doxy, which you might know. And the question arose when the AI Act started, how do we combine those two works, basically, those two regulatory issues? And is now the GDPR really void and null because we have advanced, and the AI Act is really what is going to be the golden standard? And we believe that our book is the golden standard on the interpretation of the GDPR. And we believe that if you understand the GDPR, it makes a lot more sense what is written in the AI Act. And so what I would like to use my 5 minutes on is basically show a bit of the similarities that we have, why we need regulation of data processing in the first place, and why we need regulation of AI in the second place, and how they interact and how we can learn basically from one to the other. Because one of the biggest criticisms of the GDPR has always been that there is so large legal uncertainty. And yes, the GDPR is not a perfect law, definitely not. And it didn't take up all of the insights one had from the Data Protection Directive, yes. But whenever I listen to someone talking in Brussels about the AI Act, I always encountered that, oh no, GDPR 2.0, we want to do it all differently. And I think the danger is now that we have a dissemination of the developments of those two major data processing regulatory bodies, and that is not justified by the intents and the intention of regulation. If you look at why data protection became data protection regulation, the core of it was to basically break the information power and market asymmetry. And this is what you are referring to, basically, that there is one or maybe two entities. We all live in a world now which is digitalized, and where most of the digitalized products are in the hand of very few. We have oligopolies or monopolies even. With very closed markets, it's extremely difficult to get in. And this is where the AI Act stops addressing the problem, because AI only functions if you have large sets of data, if you have big data from different sources, et cetera, et cetera. So who is really in charge of having this data, having access to the data, and having access to the technology? Unfortunately, we're not able to create our own AIs, at least most in this room. I think Sophie might, potentially, I don't know. So this is really at the bottom line of both of those laws. There's market asymmetry and there's informational asymmetry, which means we as individuals can be exploited if someone has the information about us. And this is, in a way, what is happening exactly as was being dealt with if someone creates a certain technology and we don't know how that technology works. Information, data is a very special good. This is what the common goods theory of economics tells us, and this is something which is in the AI Act included as well, but nobody really talks about it, and this is very sad. And in our introductory piece of the GDPR, trying to evolve really why there needs to be a data protection regulation, that's something we also point out. If you have common goods in the economic sense, you have market failure and you have external effects, and that's exactly what we observe. And we see the same thing with infrastructure, which is basically AI systems. Now, when we look at the tools which are being proposed, then we see they're pretty much the same, and that is transparency, we have some kind of regulatory bodies, we have some kind of certification, etc. Yes, the AI Act claims that it has a regulatory regime of product liability and that it is more prone to risk-based approach, but we see that in the GDPR as well. The GDPR is not the strict law and order administrative approach it once used to be. It has a lot of tools, and what you just described, the Article 25, for example, also Article 35, are clear instruments of risk assessment and of doing a very similar approach. So why not use the tools that we have from the GDPR and from data processing laws, which have started in the 1970s and not just in 2024, and take some of the lessons into the AI Act, and so thus create more certainty, reduce the uncertainty there. And also learn from the mistakes of data processing regulation and not do the same mistakes in interpretation. And I'm stressing this on the interpretation of the AI Act, because the Act is there. We're not going to change it tomorrow, so we have to live with what we're doing. So we should not stop at claiming that there needs to be transparency, because all of us know basically we're being exploited, but we're trying to ignore it because we don't think there's an alternative to those things. The GDPR tries to break with that by saying consent is only possible if it's free. And if it is a free consent, then, well, okay, or pay models don't function because they give you a choice, which is not really a fair choice in that sense. So this is something we can learn from AI too. The second thing is both the GDPR and the AI Act don't take into account that we have systemic digitalization. We're thinking in systems, not in intersections or communications of one party to the other party, or me to an AI system. AI is, and with ChatGPT, generative AI as such, this has become something that everybody can use, can plug in. So we're seeing now that we have a multiplicity of parties, and we are not taking account into this. The GDPR, I believe, is better than the AI Act in that, because the GDPR at least knows something like a joint controllership. And the joint controllership is the idea of creating, if there is a system, that those involved in the system and having an influence in the system are all, as data processors, responsible. We don't see that in the AI Act, but we see, yes, the computer scientists at the starting point are involved too with certain requirements, and we see that the users of AI systems have that, but we don't see that it is an entire, like a joint controllership where one takes up the responsibility of the other. And this creates incentives to really take care where and whom am I employing. And to finish this up with is, we should also look at the huge amount of expertise which has gone already into the data processing regulation and interpretation. I've just, for a different paper in which I was comparing different measures within the GDPR, looking at what has happened on the level of courts and of supervisory authorities. And as we have those 27 member states and 27 and more supervisory authorities, but we only have one European Court of Justice, I limited myself to the European institutions, and that's also because I comment the EDPB statutes together with, I saw Franziska sitting in the room, who's also commenting on them, and also on the damaging and liability part of the GDPR. So there's a lot in common. We see that there have been somewhat like 220 decisions of the European Court which deal with data protection in the last years. I don't know what the court did other than data protection, to be honest. I mean, it's clear that they're trying to create certainty. It's clear that they're trying to give this framework some more precision where needed. The same is true for the European Data Protection Board, which is the supervisory authorities board. And it's a very unique process which was created, and I think it's something which outside of Europe, you know that better, has been observed extremely attentively because it's a good way of creating a common body. We have more than 200, I've counted it, and this is probably not the latest number, I checked this about 3 weeks ago, 220 guidelines alone by the European Data Protection Board. And those guidelines are a little bit like our commentary because they're super clear in stating out what is the issue they're dealing with, what is the next step, how do they analyze this, and then they go word by word. So this is a super good guidebook in understanding what is meant in the individual provisions. So I see that the uncertainty gap on the side of regulation is closing in. What we see is, and this was a wonderful statistics, the speed of digitalization going up, which means, of course, there needs to be a continuous issuance of new guidelines and of adjustment, but that's the old game between technology and law. And so I think we should take the lessons learned from the GDPR, not forget that the tool of both, or the regulatory regime of both, is the same, and that is to leave the power of decision to us individuals and not to some third-party wild animal we don't really know who is behind that. Thanks.
Thank you very much to all speakers. I had some comment for Marco. Thank you very much, Marco, for your speech. What I noticed last year, I was involved in a research project for the European Union, and the European Commission already asked that technical and organizational measures in the sense of 25 were taken for AI systems, even though the AI Act was not adopted yet, taking into account the measures in the proposal for non-AI risk systems. We developed some system that was not, and they already required it. So totally agree with your analysis. Regarding the uncertainties, yes, case law, of course, is important. And as you said, Intra, there is a lot of case law going on for the moment, in these last 2 years in particular. But as Sophie said, yeah, we need to be fast because the progression goes fast. And can we wait so much here for case law, you think, in the case of the AI Act?
Yeah, I think that it's not really the case. This is actually what we need to do in terms of gathering various sources of information. Here, of course, the case law is if you're going to tackle every single of this kind of interpretative standards, especially given that AI is a highly general technology. So even though you have some systems that you can create for certain specific purposes, there are various others in which you can use the same base technology to generate things, generate some silly jokes with your friends and generate high sensitive contracts. So it's not really a job that can be tackled simply at the level of case law, although of course the case law will give us the more certainty on that in terms of legal. But given that those gaps, this will require a strong combination of sources here, drawing from experiences of other parts of the regulatory frameworks. And here's where in Professor Inder's call of, okay, let's look at the experiences of the GDPR becomes particularly salient, and also not just that on the non-binding. And here's where I was particularly happy of your point on the Commission already taking into account that the AI Act's guidelines and provisions for the measurement, for using the AI Act as guidance, even for non-high-risk AI systems, because there are similar obligations in the GDPR. But even then, you still have something of different levels of uncertainty, because even those measures, what the AI Act requires, if you go there, that's still not dense enough for interpretation to be implemented by the technical actors. So if you are going to transform that into software measures, you're going to need more. Then the AI Act resolves that with technical standards. But the technical standards themselves, they're still, depending on the text of the standard, varying levels of discretion that's left to the technical actors on how do we there are multiple possible realizations of that standard that might comply with that, even if you manage successfully embed human rights factors into the standards, which is another big question. Then, even that, there's still some degree of uncertainty that is left there, decisions that often are left to the technical actors. So this is why we need to rely on those multiple sources and those varying degrees, which will come on varying degrees of certainty, but it will have to be an ongoing learning process, at least for the near future.
Thank you very much.
I'd just quickly jump in onto this because the technical standards is something which the AI Act makes really, really big. And the GDPR started out by saying the Commission will do everything, lots of delegated acts. And in the course of the GDPR, then a lot of the actors said, no, we don't want all the power with the Commission. And with the AI Act, I sometimes think, well, maybe the power with the Commission would have been a bit more of an assessment of independence, at least to some extent, than handing it all over into standardization procedures, because the standardization procedures, if you look at who is at charge of that, that is just a selected number of players in the game. And we don't have, and this is different from environmental law, for example, where we have the so-called Sevilla process. And the Sevilla process is something where the law sets very clearly, okay, we'll do standardization, but those standards are going to be set in a very complicated process, and that's why Sevilla for a couple of weeks is booked out, and you can't get a hotel room when they all meet there. But it's clear who can play along, and this is totally unclear in the standardization, and we see that in the GDPR as well with the certification standards. We have certification as a backbone, the idea that there's self-regulatory tools, etc., and certification is big in the AI Act as well. And again, it's kind of a trickling down of responsibilities again, and in the end, it's the interested parties who have the power, the money, the resources, and the technological knowledge to really play a part, and I see that as really problematic.
if I may quickly follow up, because I totally agree with those points that have raised, and I would like to add a further dimension here, which is, okay, the AI Act in particular is premised on the reliance on harmonized European standards, but given that there is this scope of interpretation that's still left, those things that still need to be understood, actors will rely from a variety of other sources, which might be even less subject to this kind of control. It's going to be still, those will be even more controlled by private interests, which might not necessarily align with some of the public aims in regulation. And there's because even though we are going to have soon enough lots of harmonized European standards for AI, actors will still read those standards, but in light of all standards being developed at the international level, because we have NIST in the US being an active organization in developing standards, you still have the international organizations such as ISO, and then those standards not only communicate with the development process of the harmonized European standards, but they are themselves being guides, relevant guides for interpretation when actors are obliged to follow technical measures to comply with their legal regulations, and those duties they have are not sufficiently covered or not covered at all by existing European standards. So you also have this interplay between sources of this privatization of how rulemaking takes place. It's not simply a matter of, this shifting to the European standardization organizations. It goes even beyond that, and this is why also why I share Professor Inda's preoccupations.
Thank you very much, Marco. I've got another question afterwards. I'll give the floor to the audience. Recently, I was talking to scientists in facial recognition domain, and they were telling me that they were using generated faces in the algorithms to test the algorithms. And I was speaking about the biometric data, the definition of biometric data under the GDPR. The question came, is a generated face, can it be or not be defined as biometric data? But it's a question. But my question here for you is, did you already identify some definitions that could cause some issues in the GDPR because of the rise of AI systems?
I'm not entirely sure I fully understand. So you're saying in terms of scope of GDPR?
I mean, could the interpretation of or the definition of the GDPR be complexified, or can there be gaps because of the development of technology, in particular AI?
So as I said at the beginning, a lot is about how you implement the rules in practice. And the big gap that I see, at least if I put my practitioner hat now, is translating. To me, the main problem is translating high-level requirements into secondary technical requirements, and a lot gets lost in that process of translation. So it's less of a problem of having a high-level framework with missing definition. It's more about not understanding the scope of some of these definitions and coming up with some secondary technical requirements that do not align with the high-level definitions. That being said, obviously, I'm not claiming that GDPR is all shiny as it is. The definition of biometric data is very narrow, so it's only when it's used for identification purposes, which is not exactly the same definition that you've got in the AI Act. So it's quite narrow. Whether it's too narrow for AI purposes, then it's being answered in the AI Act because they have a broader definition. It's very hard to think in the abstract. You need to see specific use cases. But to me, the main problem is at that translation level. And then just to go back to the point that you were making about case law, if you have to build the frameworks on the ground, it's more the regulatory guidance that the regulators are issuing that is going to guide practice, because they tend to be more comprehensive. Obviously, case law looks at specific questions. and what you are facing in practice rarely fits the exact facts of the particular case. So what's very useful is the regulatory guidance, and what would be even more useful is like trying to train more people to work at the interface of both worlds, I think, because that's very much missing, and this is where the what I call the compliance cascade starts, because all the nice high-level rules that have been formulated get lost in the implementation stage.
Thank you. Yeah, Indra?
In the commentary, the person who's doing the personal, the definition, Article 4, number 1, on what is personal information, etc., is with a... Is that you?
It was me.
Ah, I'm sorry.
That was me.
I was thinking it was
Okay,
someone
I can
from
say
Data
something.
Protection Authority, and
No,
that's why he's
fine.
not here.
Okay, I'll say something later. Okay.
Then you go.
Okay, thanks. That was not rehearsed. Right? That was, yeah. I think that it's fine. Okay, this gets me to my second biggest complaint with the AI Act. I think, and this is the risk-based approach. So I think that the GDPR definitions are fine, and it is an excellent example because that was what I had in mind. Personal data, identified and identifiable. So synthetic data, the ones you asked about, is fine. It can't be classified somewhere there. So the definition of personal data still stands. And please keep in mind that the definition of personal data is the same even before the internet was started, because it's the same since the directive. So it's the same since 1992 when it was drafted. And it's the same thing, and it still holds. Why? Because it is not case-specific. It is not a risk-based approach. And this is my complaint with the AI Act. And the GDPR version, the risk-based approach presupposes, is based upon an understanding that we understand the risk. And we aim at the risk. So we classify, high level, mid-level, low level, okay. Or in the GDPR, we classify DPA necessary, non-DPA necessary, okay. But then it means that we understand the risk. So we are all focused on the risk. But if you cannot understand the risk, and it's most likely that most of the times you will not be able to understand the risk, because please also consider that the GDPR is about human behavior. So, okay, if I say something, this is my behavior, this is the end result, it is visible to you, and you can classify my saying, but the AI Act is about the tool that I'm using. It's about the microphone that I'm using to get the message to you. So it is not easy as it has been in the GDPR to classify risks, which even in the GDPR, it is its second nature, the risk classification. It is only about the DPIA and the sensitive data, but the main stuff has been with us since the 90s, and it still holds. And this is my complaint with the risk-based approach. It's, short-term, 10-year, we have to revisit. Whereas the other thing, the core of the GDPR, personal data, the definition of personal data, will be with us for 50 more years. Yeah.
Can I still add? Thanks a lot. And I'll go to the question you asked on the synthetic data, really. I think you have to read the GDPR, and this is right on our topic here, together. Because the GDPR helps to make understandable a little bit better, and I'm not saying fully better, what is going on in order to train AI. And then comes the AI Act and thinks about the outcome. And this is where the GDPR partly hits again with some of regulations, because it says that if you have a fully automated decision, then the GDPR kicks in again. So you have a constant interplay between those two. And we've seen that in classical profiling as well. You have a part where there is the GDPR applicable. That's when you take the personal data of people in order to build a model of big data. Then you use all of this anonymized, pseudonymized data where you typically have no interest in the individual behind it. You're just interested in the mass thing, the most people who behave like this, also like this, blah, 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 blah type thing. And then you attribute it again to an individual, and that's where the GDPR kicks in again. And I think that we should try not to get stuck in this too much thinking about, is this GDPR 2.0 or not? We don't want that blah, 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 but to understand that both of them are very much interlinked and intertwined. So you need, for the synthetic data, you need natural data, of course, and most likely personal data, because you train with particular faces, blah, 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 blah. Where do you get those from? And then you use that, and then you employ it in order to detect someone, to do surveillance, etc., etc. And that, again, is GDPR something. And this is maybe one of my additional, I'd say, complaints about the GDPR and the AI Act, that they haven't really linked this together. There is just the stupid provision in the AI Act that it doesn't change the GDPR, which is nonsense. And everybody knows, and that's why we excluded it from this podium, that if you want to have a control of the quality of data, then you need a lot of data, obviously, and this is not data minimization by the GDPR. So how do you combine those two? With the EDPL board, we gave out an award for that for a Young Scholars paper last year. But there's much more to that, and we still haven't really understood what is going on behind the scenes, and that's where we need to get at.
Thank you very much.
Sorry, can I just add one thing on
Sorry.
synthetic data? For having worked just a little bit on pets, I think we need to be careful with words, and we need to define terms. So when synthetic data is purely derived from personal data without any further sanitization processes, then this is also creating risks for the individual. So re-identification risks are not being mitigated. These are purely aggregates. So yeah, it's maybe it would help if we had like a threefold distinction between personal data, data derived from personal data, and then non-personal data. Maybe that would be clearer. But if I started my presentation by saying, how do we address legal certainty? And my answer was, what if we use common sense? I think that's missing sometimes. We need to be very careful about definition, I think. If we do that, we can reach a certain level. It's not going to be the ideal position, but probably a little bit better than where we are at today.
Thank you very much. I'll open the floor to the audience. If you have any questions, do not hesitate.
Yes, so my name is Chrissy. Good morning, everyone. Thanks a lot for the amazing discussion that we're having today. So I wanted to ask or share my thoughts and then try to see the thoughts of Vangelis regarding the first argument he had on the AI individualization. So I'm trying here to see if, for example, this is something intentional that comes from the companies, because I try to imagine that I own a company and I develop certain services and tools, and I wanted to offer them to the people, but at the same time, I want to develop the tools and compete with other companies and beat competition. So in that regard, I would like to avoid additional GDPR compliance obligations, for example, when it comes to the exercise of the data subject rights. So there, I would like to offer a non-personalized version of this service in order to avoid having additional obligations when it comes to the right to access, the right of deletion, but at the same time, saving some resources from creating privacy dashboards where each user can exercise their rights online and so on. So what are your thoughts about that? I mean, how this connects to the right to AI individualization, in your opinion? Thanks a lot.
Thanks. That's an interesting question, and my idea is still half-baked, so yeah, I'll take that into consideration. My immediate response would be that, yes, it is intentional. So it should be an option like privacy by default, privacy by design, individualization by design, so that I can do this. Now, if I have to pay for this additional, or if I have to be technical savvy to do this or whatever, or if I'm not interested to do this for Amazon books, but I'm interested to do this for Spotify music, so I can play around with this. But I need to have the right. I need to have the right to carve out some AI from these guys, create my own, and keep it my own for the moment, and we'll see. But again, it's half-baked, so yeah.
It's just one comment, and I'm returning the mic. I just wanted to comment that actually, just wanted to explain that that's absolutely possible. It just requires more technical technical knowledge, but it's absolutely possible. There are open AI models. And as a comment, of course, this is just a gossip, but probably within 2-3 months, actually Siri will be on the device. So
what will be on the device? Excuse me, because of
Siri, actually, the AI on the Apple will be on the device. So at least that's concern of yours will be addressed.
There was a question behind. Yeah, yeah.
Which one?
Giancarlo Margeri, Leiden University. Thank you so much. This was a very interesting topic. I wanted to trigger your in reactions on Article 7 of the AI Act, because about certainty and risk, I think this was on the table. Article 7 mandates, gives some indication to the Commission to update the high-risk list in the future, right? How do you see this in this legal certainty versus legal uncertainty mechanism? You mentioned risk, in particular, Indra mentioned risk in the GDPR and risk in the AI Act. That's different. Also, Vagelis mentioned this. I think if we believe that risk to fundamental rights is a technical notion that can be developed by judicial case law and technical notion, this would be the GDPR approach, where risks can be updated by EDPB and DPA, like the high risk. The AI Act seems to take another approach, seems to think that the definition of risk to rights is political. Well, the Commission is administrative, but there's also a political drive. So I was a bit puzzled to read that a high-risk list can be updated just by the Commission, not by a case-based, AI board, surveillance authorities, etc. Do you share this, skepticism, or do you think Article 7 is good?
I'll jump in. I totally agree, and I think it's one of the big flaws that the right of individuals to force or to enforce the regulatory tools within the AI Act is just totally neglected. So if the Commission decides, for whatever reason, nothing has changed, there are no additional high risks, then the society could believe that this was super high risk and the Commission could not be forced in any way. I don't see how you could do that. So totally agree.
Other thoughts? No.
Yeah, total agreement. No,
okay. Yeah, I agree as well. Other questions in the audience?
Hello, everybody. First of all, thank you so much for this excellent panel. Well, my question is kind of similar of the one that Gian Claudio raised before, but it's about the approach that the Court of Justice of the European Union is going to take, because with the GDPR, as you mentioned, we have more figures, and even though that we have legal uncertainty, there's a huge amount of case law, and there is a clear procedure of how to react when there is a breach of the rights of the data subjects. Don't forget that we are regulating about data and not humans, so it's the data subject, not the human itself. And then in the UAI Act, we are talking about the AI systems, and we connect these systems with the risk to the fundamental rights, to the ones that are going to be part of this system. So my question is, when in the future or in the present there is going to be a challenge to the Court of Justice of the European Union about how to solve a problem regarding the UAI Act, which approach is going to be taken, because how the court is going to give an answer to an AI system breach of rights. So I would like to hear your thoughts about it and how this problem could be solved in the present or in the future. Thank you so much.
Who wants to?
Oh, yeah. Just some brief comments before leaving to my colleagues. This is indeed a challenge here, given the very procedural problems that you have here in tackling whatever's going on. You have a huge question of standing here in terms of the AI Act, if you want to directly contest these kind of things, where you have those measures that are going to shape what we want as fundamental rights protection, what we as a society wants should understand as protection, democracy, and rule of law, that are being settled in documents that, at the end of the day, a private actor won't have really standing here. And one way that might be possible for this kind of contestation is it taken indirectly, and here, having the GDPR system, here's why, one more reason why it is important to keep in mind the integration, not look at this as separate clauses. This is an AI Act problem, this is a GDPR problem, because especially when it comes to individual and group effects, you're going to have those things happen together to make sure that you have proper channels of action in which might, in the context of personal data, you might need to incidentally question those provisions. But yeah, indeed, you have very limited channels for direct action on anything here.
To follow up the question, do you think that the court, the ECJ, could have case law in a matter of Article 22, automated decision-making, taking into account the provisions of the AI Act?
Yes, because when it comes to AI systems, it feels quite difficult to unpack, because in order to fulfill your obligations under Article 22, and when AI system comes involved, and then you having the definition in the AI Act itself becomes a way to bring that into the fold, then you are going to, when determining the measures, because we have to keep in mind that the measures on 22, paragraph 3, I say at least the right to contest, the right to human intervention, and so here, when it's read, those measures on high-risk AI systems, and by extension, when we are that thing we were discussing about non-high-risk AI systems, but then you have this important to keep in mind that the list offered by Article 22 is not a closed list. So it's not simply that if you exhaust those three rights of ensure that people have the right to contest, the right to request human intervention, the right to object, to manifest their, they won't have, that's not exhaustive. And so when you have another normative dispute here, this will become probably the main channel in practical terms of one question, because this is where you have the direct interface of the technical requirements laid down in the high-risk contest and the standardization, which even if standards are designed for high-risk systems, they're still going to provide guidance for those who are dealing with not high-risk AI systems. And then when we're talking about harmonized standards, we have the question of the legal value ascribed to that, which opens the possibility of contestation in the courts, but we still have to see how that will play out in place. To which extent will the court follow up in its by now consolidated understanding that those, at least the harmonized standards published in which the reference published in the official journal are part of the EU law, how much the court will follow on that, but that might be a way to explore, to have some possibility of control, things that are legally pretty removed from the individual, but end up having much impact on their lives.
Yeah, thank you. Yes?
Sorry. One question might be more about uncertainty in GDPR. What do you think, if you can answer, why in some articles of GDPR there is a notion risk to the rights and freedoms of natural persons, and in other there is a data subject? Why is those two different meanings? Why it is necessary to mention this natural person instead of data subject in every article? Thanks.
I would like to argue that that's because the GDPR is also concerned about groups of people. So when you do your assessment, you should actually go beyond the impact that you are generating for the particular individual. I would like to think that's the case. Whether that's the case in practice, I don't know.
Yeah, I never thought about this, I'm sorry. Yeah, so it's food for thought, no? Yeah.
And that's actually what we argue in Article 1. We have that, and it says, and that's why I made the point about external effects. It's not, and that's the problem with consent. I'm consenting to my data being used in order to assess Vagelis, or in order to address an issue with Sophie, and they have absolutely no say in what I pass on as data. And that's something, for example, in Article 6, section literature F, then we have a balancing of interests, and that's not just a balancing of interest of the individual, which is now at stake, but it is of all the external effects involved.
Hi, Emanuel Bougiakiotis from the European University Institute. I wanted to come back to the issue of the scope and the definition of personal data and ask for your reflections on two issues. The first one is the law of everything that Nadia Pertova wrote about, and the very broad scope and increasingly broad scope of the definition of data. But the second one is exactly the issue of externalities, of external effects. So if I give away my data and they are able to infer information about third parties, their legal status is very unclear. Are they data subjects, are they not? We have seen this a bit with genetic data too, but there's basically no answer. So is the whole concept and the definition of data in the GDPR still fit for purpose, given that we have those external effects? Thank you.
No, I'll run last because I have... No, I'll run last because I wanted to run last to address this, because the point is that being the law of everything, it is the law of everything, but it is our life that has been digitized. So the general idea is that in the very same way that in the analog, in the real world, we have laws about everything, we slowly need to develop laws about everything in the digital world. And this will be a procedure for us, for humanity, for legislator, and we have to address in the digital domain and in the data processing domain questions such as this, which in the normal world are more or less resolved through criminal law, defamation law, right of personality. So in day-to-day circumstances it is resolved, but now when the digital comes in, changing everything, we need to reassess practically everything. So there are bound to be problems, because we are in a humanity intermediate stage that has been unprecedented. We never had to deal with this. We never had data. Never ever, not like 100 years, 200, never ever, ever. So we need to reassess how does this really work. So yeah, there are bound to be problems about inferences that are solved in day-to-day life. So, yeah.
No, it's not a perfect framework, as I said. Do you have a better solution? It's also very hard to find. What should be more explored is this concept of collective rights, which is not there yet. Some inspiration could come from copyright, for example. So you've got a work, and then you have derived work, and then you have to take into account several types of stakeholders. But yeah, again, it's not perfect. But the more we can use some common sense, the better I think we are here.
Yeah, and this point on common sense is very critical in this case, given that the concept of definitions, if you are trying particularly hard to avoid making this the law of everything, one thing that must be kept in mind is that you're dealing with a moving target. For example, in the passage about Article 411 on pseudonymization on the GDPR, we discuss this, that we have the criteria of what counts a perfect anonymization. There is a tendency towards an absolute view as opposed to something relative, but considering that technologies, and here AI-based technologies can be a particular challenge for what's happening, might allow the methods of re-identification that are not here. At a certain point, you have the choice, okay, are we going to overextend for a more conservative perspective, that is, embrace this as the law of everything, or are we going to set up, oh no, this is the line where the compromise happens and incur the risk that something that's not personal data today might be 6 months from now. And this is where it comes to Vagelis's point on how we need to recontextualize, re-dispute certain things that we take for granted on analog environments, but suddenly become up for contestation when we deal with increasingly digitalized society.
Thank you very much, Marco, for this conclusion. Thank you also for the audience for their questions. Thank you.